I tried to drive into my own ranch on a Tuesday morning, and a new electronic gate stopped me cold. The gate had not been there on Monday. The keypad was new. My code from 48 years of cattle drives did not work. Behind the gate, holding a cup of coffee and a Big Hole River Estates polo, was Madison Cartwright Steele, HOA board president, Montana. 45, polished, blonde, certain she could fence off 70 years of my family's recorded access easement with a 4-digit code. Mine is Augustus Kane. I'm a 4th-generation Beaverhead County rancher. By the end of the month, the clubhouse her HOA had used since 1976 was padlocked. The 99-year lease was revoked, and a Montana judge had personally barred Madison from setting foot on the 8 acres her own community had built on. What would you do if a stranger locked you out of the land your great-grandfather had homesteaded? Where are you watching from tonight? Stay with me. My great-grandfather Erastus Kane filed the homestead patent on the South Fork of the Big Hole River in October of 1881. He had come up from Missouri after the Civil War with a string of 14 horses, a Sharps rifle, and a small leather Bible that lived in his saddle pannier until he had a roof to set it on. The original homestead patent was for 160 acres. He proved up the patent in 1886. He added another 160 by purchase from the railroad in 1889. His son Ainsworth Kane, my grandfather, added 680 acres in 3 transactions between 1907 and 1924. My father Tully Kane added another 6,400 acres across 30 years in the slow, careful way Beaverhead County men acquired land in the middle of the 20th century, at the funeral of a childless neighbor, at the bankruptcy sale of a winter-quit cattleman, at the auction of a Forest Service grazing allotment my father had run for 19 seasons. By the time my father died in 1991, the Kane Ranch was 7,400 acres of native rangeland, 260 miles of fence, and a cow-calf operation running 400 Hereford Angus crosses on summer pasture and a winter feed yard. I took over the day after my father's funeral. I was 31. My wife, Eulalia, Lally everyone calls her, and I had been married 8 years. Bryson was 4, Maeve was 2. Lally worked at the Dillon Large Animal Veterinary Practice as a vet tech for 32 years before she retired. She is 62 now. She is the toughest small person I have ever met. She is also the only woman I have ever loved. The Big Hole River Estates development sits on the eastern edge of our ranch, on what had once been our home pasture. My father sold the eastern 240 acres to a Bozeman developer named Crowfoot Development Group in 1976, the year I turned 16. He sold it because the rangeland tax assessor in 1975 had reclassified our home pasture as developable land for property tax purposes, and my father could no longer afford the new assessment without selling part of it. He chose the eastern 240 because it was the flattest, closest to the new highway, and farthest from the river bottom where our calves wintered. He hated selling it. He hated it the way ranchers hate every transaction that subtracts. But he was a careful man, and he insisted on 3 things in the sale contract that would, 48 years later, matter more than any of us could have predicted in 1976. The first was a permanent 30-foot wide access easement running from State Highway 41 west across the development to the boundary of the unsold ranch. The easement was recorded with Beaverhead County on the 3rd of November, 1976. The recording instrument number is 1976-1841. The original document is in the safe in my office. The easement was described as perpetual for the benefit of the Kane Ranch and its successors in interest for vehicular and equestrian access in support of agricultural and residential use. The second was a 99-year ground lease of 8 acres at the southwest corner of the sold parcel, the spot where the developer wanted to build a clubhouse and a small pond for the residents. My father leased the 8 acres to Crowfoot Development Group for $1 a year, with annual rent payable on or before the 1st of January. The lease term began on the 1st of January 1977. The lease was scheduled to terminate on the 31st of December 2075. The lease, however, contained a revocation clause, a 6-paragraph addendum my father had insisted on against the developer's polite resistance. The clause allowed the lessor to revoke the lease on 90 days written notice for material breach, including failure to pay rent for 2 consecutive years, unauthorized alterations to the leased premises, violations of state or federal environmental law affecting the leased premises or adjacent ranch land, and any conduct injurious to the lessor's quiet enjoyment of the adjoining agricultural operations. My father had insisted on the final phrase. The developer's lawyer had argued for 40 minutes about it. My father had said, in his 300-word-a-week voice, "Then we don't have a deal." The developer had signed. The third was the right of first refusal on any future sale of the sold parcel back from any subsequent owner. We had never needed it. We have it. Crowfoot Development Group built Big Hole River Estates in 1976 and 1977. 70 homes on lots between ½ an acre and 2 acres, around the clubhouse, the pond, and a small tennis pavilion. The development opened in 1978 with 23 homes pre-sold. By 1985, all 70 lots were built. The HOA had been formed at the opening, a small board of 3 residents and the developer, transitioning to a full resident board in 1988. Big Hole River Estates spent its first 30 years as a quiet, polite second home community for Helena lawyers, Bozeman professors, and a handful of retired Air Force colonels from Malmstrom up in Great Falls. The HOA paid its $1 a year on the 1st of January every year. I framed the first one in 1992, the year after my father died. I framed every January dollar after that. There are 33 framed dollars in the hallway between the kitchen and my office. The frames are cheap. The bills are real. My father had taught me to keep the receipts the way he had taught me to keep the cows. Madison Cartwright Steele moved into Lot 47 of Big Hole River Estates with her husband Brody Steele in the spring of 2019. They had paid $2.1 million cash. Brody was a senior executive at a Houston-based energy company, the kind who flew to Montana in a Cessna 414 on Friday afternoons and back to Houston on Sunday nights. Madison was 41 at the time. She had been a marketing director for a Dallas-based real estate brokerage. She wore tennis whites to grocery stores in Dillon. She drove a black Audi Q8 with a vanity plate that read MCS1. She got herself elected HOA board president in May of 2021. She had run on a platform of elevating the Big Hole River Estates brand. She had won by 38-9. I want to describe Madison the way Beaverhead County saw her. She walked into the Dillon Albertsons on Saturday mornings in matching pink Lululemon and tipped the bagger nothing while complaining about the produce. She drove the Audi Q8 the way a woman drives a car she is renting from a hotel, fast through curves, slow at the stoplights, never with both hands on the wheel. She had a habit of describing her husband Brody's job as energy infrastructure work, while making a small face that implied infrastructure was beneath them. She had 2 part-time housekeepers, one Filipino, one Honduran, both of whom shopped at the Dillon Walmart on Sundays, and both of whom Lally had befriended by January of 2020 over the question of whether Madison's preferred laundry detergent was actually any better than the store brand. The housekeepers reported, in confidence over the years, that Madison referred to me in private as the old cowboy. Lally had reported that one back to me on a Wednesday evening with a soft smile. She had said, "Augustus, that woman believes you do not own anything. Someday she is going to find out." We had laughed at the time. We were laughing about something we had not yet earned. She wrote me her first letter on the 14th of June, 2021. The letter requested that I instruct ranch personnel to observe the development's posted speed limit of 15 miles per hour at all times during access transit. I had no ranch personnel exceeding 15 miles per hour. My oldest hand, a 61-year-old former rodeo rider named Sully Brock, Different Brock from previous stories. Just a Montana coincidence. Drove a 1998 Ford F-250 with a topper at no faster than the truck wanted to go, which on a wet morning was 12. My son Bryson, who was by then the ranch foreman, drove a 2011 Dodge at 14. I drove a 2003 GMC at 13. Madison's complaint was, in the dry language of Beaverhead County, a fiction. I wrote her back politely. I explained that our access vehicles operated below her posted limit. I attached a one-page log of access times for the previous month. I sent it certified mail. I framed the return receipt. The frame is small. She wrote me 21 more letters between June of 2021 and May of 2024. I framed 7 of them. By the spring of 2024, she had filed 11 complaints with Beaverhead County about my fence height, my cattle trailer rear lights, my hay deliveries, my bull turnout schedule, and one memorable complaint that claimed my 4-legged ranch dog had snarled at HOA children on a Saturday in August of 2022. The dog in question was a 13-year-old Australian Shepherd named Mavis, who had been deaf since 2019 and who slept 18 hours a day. Beaverhead County had dismissed every complaint with the kind of efficient courtesy small western counties use for East Texas marketing directors. Madison had escalated regardless. On the night of the 3rd of May, 2024, she crossed a line my father had warned me about in 1976. The morning of the 4th of May was a particular Beaverhead County morning. The temperature at our porch thermometer had read 26 degrees at 4:30 when I had filled the coffee pot. The Big Hole River fog had not yet lifted from the bottoms. The smell of the alfalfa I had loaded the previous night was thick and clean. Second cut, baled tight, the cleanest crop we had brought in the previous fall. I had been driving cattle and hay through the eastern gate since I had been old enough to operate a clutch. My father had taught me to do it at 12 in his 1962 GMC stake bed. The eastern gate had been, for 48 consecutive years, the first object I touched on any working morning of my life. The gate had been a swing gate. The swing gate had been the same swing gate. I had repainted the swing gate red in 1989, and again in 2008, and again in 2021. The bolts on the swing gate hinges had been replaced once, in 1994, by a hand named Carlton, who had worked the ranch for 19 seasons before he retired to Lewiston. The gate, by the morning of the 4th of May, was 48 years old, and had been opened, by my rough estimate, around 23,000 times. I drove down to the eastern gate at 5:40 a.m. on the morning of the 4th of May. I had a hay trailer with 3,000 pounds of second-cut alfalfa for the back pasture. The gate had been a simple swing gate since 1977. Heavy steel pipe, no lock, 2 iron hinges, a counterweight. I had operated the gate for 48 years. There had never been a question about who had access to it. Every Big Hole River resident had used the same gate every day for 48 years. The ranch had used the same gate. The fire department had used it. The propane delivery had used it. The gate that morning was new. It was an electronic gate, 8 feet wide, powder-coated black, a small keypad mounted on a steel post, a magnetic lock at the latch. The gate was closed. The keypad was lit. There was a small sign zip-tied to the lock that read, "Residents only. Code required. Big Hole River Estates, HOA." I stopped the truck. I got out. I tried the swing gate code we had used since 1977. There was no swing gate code, because there had been no lock. I tried the access protocol the fire department had used. I tried the 4-digit code Madison had been emailed by the HOA management company the previous week, which Bryson had forwarded to me as a courtesy. None of them worked. I called Madison from the cab of my truck at 5:47 a.m. She picked up on the second ring. She was already awake. I said, "Mrs. Steele, this is Augustus Kane. I am at the eastern gate of Big Hole River Estates. My ranch access code is not working. I have a hay delivery to make this morning. I need access immediately." She said, "Mr. Kane, the HOA has updated its security infrastructure. Access is now restricted to verified residents. You are not a verified resident. You may apply for guest access through the management company. The application process is approximately 14 business days. I said, Mrs. Steele, I am the owner of the access easement. The easement is recorded with Beaverhead County, instrument number 1976-1841. I have the original document in my safe. The easement is for the benefit of my ranch. It cannot be gated against me. She said, Mr. Kane, the HOA's gate is on HOA property. The HOA controls the gate. You will need to apply through the management company. I said, Mrs. Steele, I am asking you once. Please come down to the gate and open it for my hay delivery. We can discuss the easement at a more reasonable hour. She said, Mr. Kane, have a nice day. She hung up. I stood at the gate at 5:50 a.m. with 3,000 pounds of alfalfa behind me and a herd of 270 cow-calf pairs in the back pasture that had not been fed since the previous afternoon. I called Bryson. He drove the back road in his pickup. He drove the 15 miles. He confirmed what I already knew. The back road was not passable for the loaded trailer. The timber bridge across Coyote Creek was rated at 4,000 pounds gross, and my trailer plus the tractor weighed 11,000. We had not used the back road for loaded deliveries since 1994. The cattle truck the feedlot was sending at 9 a.m. would have to be turned around at the gate. I called my daughter Maeve at 6:30. Maeve Kane is 32. She is a senior real property attorney with the Montana Attorney General's office in Helena, where she has worked since 2017 on rural land disputes, easement enforcement, and conservation property cases. She picked up on the first ring. I told her in 7 minutes. She said, Dad, do not engage with her. Do not approach the gate again today. I am driving up tonight. Bryson, turn the cattle truck around at the highway and tell the feedlot driver you'll reschedule. Bryson, do not cross any fence. Do not damage the gate. Dad, go feed the cattle through the back road on foot with the tractor cart and 12 square bales. I will be there by 7 p.m. We are going to do this right. While I waited for Maeve, I fed the cows through the back road on foot with the tractor cart and 12 square bales. The work took 3.5 hours. Bryson met me at the back pasture at 9:30 in his pickup. The cattle were spread thin across the south meadow, watching the bottom of the slope for the sound of a tractor. I crested the rise on the old Massey Ferguson with the cart trailing 12 bales. The cattle came to me at a slow walk. They recognized the tractor pitch from a quarter mile out. I cut the bale strings with my pocket knife and forked the alfalfa across the snow-melt wet sod in a 30-yard line so no single cow could push the calves off. Bryson cut the strings on the next 4 bales. We worked without talking. The work itself was the conversation. The cattle settled. The calves found their mothers. The yearling heifers we had kept back from sale moved to the edge of the line, the way young animals always test the edge first. By 11 a.m. the herd was fed and quiet. Bryson and I sat on the tailgate of his pickup and ate the breakfast burritos Lally had wrapped in foil at 5 a.m. We did not talk about Madison. We did not need to. She arrived at 6:57 that evening with a roller bag, a laptop, and a thermos of black coffee. She kissed me on the forehead. She sat at the kitchen table. Lally poured her a cup. Maeve opened her laptop. She said, Dad, get me the safe. I brought her the safe folder, the 1976 easement, the 1976 ground lease, the 33 framed January dollars on the wall. Maeve laughed once at those, the way you laugh at a thing your father has been right about for 30 years. The HOA's most recent management company contract, which we had a courtesy copy of. The land grant patent from 1881. Maeve read for 4 hours. By midnight, she had a 40-page memo on her laptop. She turned the screen around. She said, Dad, we have a clean injunction case on the gate. We will win it in 2 weeks. But that is the small case. The big case is the lease. I asked her what she meant. She said, Dad, The 1976 ground lease has 6 material breach triggers. Madison Cartwright Steele, as HOA board president, has triggered 4 of them in the last 3 years. I asked her to walk me through them. I want to describe Maeve at that table for a moment, because it matters to the rest of the story. My daughter is the careful person I had hoped both my children would become. She had grown up at the kitchen table, watching her grandfather's framed dollar bills be added one by one. She had taken her undergraduate at Montana State in agricultural economics. She had gone to law school at the University of Montana in Missoula because she had wanted to come home. She had clerked at the Montana Supreme Court before she had taken the Helena AG position. She had 4 pencils in her shirt pocket. She had a small spiral notebook in her hand. She had her grandmother Cordelia Kane's old gold reading glasses on a chain around her neck. Cordelia had been a schoolteacher in Wisdom for 31 years, and her glasses had hung on the same chain in the same kitchen since 1962. Maeve was the 3rd generation to wear them at that table. She was also, by 2024, the most clear-headed property attorney in 3 counties. She was, that night, 15 pages into a memo she had drafted at the AG office in 2022 about exactly this kind of HOA ranch boundary dispute. She had filed the memo under a working title she had told nobody about. The title, when she opened the document and turned the screen toward me, read Cane Ranch Scenarios. She had been planning for this moment for 2 years without telling me. I learned later that night that she had drafted the memo because she had read one of Madison's complaints at her office in 2022 and had recognized the pattern. She had not told me because she had wanted to be ready, not paranoid. She had been ready. She turned the laptop toward me. The 4 triggers were, first, the HOA had failed to pay the $1 a year for the years 2020, 2021, 2022, 2023, and 2024. 5 consecutive years of unpaid rent. The lease specified that 2 consecutive missed years constituted material breach. Second, the HOA had built an unauthorized extension to the clubhouse, a 600-square-foot covered deck with a built-in outdoor kitchen and a stone pizza oven, in the summer of 2022, without seeking the lessor's written approval as required by the lease. The cost of the extension had been $146,000. The construction had not been disclosed in any HOA newsletter. I had not known about it until Maeve pulled the county building permit. Third, the HOA had been discharging storm water from the new outdoor kitchen and the expanded patio directly into the clubhouse pond, which then overflowed into a small wetland on my adjacent ranch pasture. The discharge violated the Montana Water Quality Act and the Federal Clean Water Act. Maeve had photographs from the Montana Department of Environmental Quality of E. coli levels in the wetland 3 times the allowable limit. The samples had been taken by a state field officer the previous September. The samples had not been brought to my attention because, until that night, no one had connected them to the lease. Fourth, Madison Cartwright Steele had filed an affidavit with Beaverhead County in March of 2023, claiming that the Big Hole River Estates HOA was the fee owner of the 8-acre clubhouse parcel. The affidavit had been filed in support of an HOA application for a property tax classification change. The affidavit had been false. The HOA had never owned the clubhouse parcel. The clubhouse parcel had been continuously owned by my family since 1881. Madison's signature was on the affidavit. The filing was a felony forgery under Montana Code 45-7-209. Maeve closed the laptop. She said, "Dad, we can get the gate open in 2 weeks. We can revoke the entire ground lease in 90 days. We can also have Madison Cartwright Steele criminally charged for the false affidavit. The HOA will lose its clubhouse. Madison will personally face a felony. The community will inherit a different president and a new lease arrangement at fair market value, which Helena's market data suggests would be somewhere around $28,000 a year. Dad, your father insisted on the revocation clause for a reason. Tonight is the reason." I sat at the table for a long time. Lally put a hand on my shoulder. I thought about my father. I thought about the 8 acres he had hated selling. I thought about the $1 he had insisted on every January for 99 years. I thought about Madison's voice on the phone at 5:47 that morning. I thought about Sully Brock and Bryson and the cattle truck driver who had driven 38 miles to be turned around. I said, Maeve, do it. All of it. We do it right. The next morning, the 7th of May, Maeve filed an emergency motion for injunctive relief in Beaverhead County District Court. The motion sought immediate restoration of unimpeded access to the 1976 easement. The injunction was heard by Judge Eleanor Whitcomb the following Tuesday. The courtroom had been built in 1903. Oak benches, pressed tin ceiling, brass railings. My grandfather had attended his own brother's land fraud trial under in 1929. Judge Whitcomb was the senior judge of the 5th Judicial District. She was 68 years old, in her 21st year on the bench, and she had grown up on a ranch in Madison County. Maeve presented our easement file. Judge Whitcomb opened the hearing at 10:02. She asked Madison's lead attorney whether the 1976 instrument was express, perpetual, and properly recorded. He hesitated. She read the instrument number aloud, slowly, into the record. She asked him again. He answered yes. She asked him whether the dominant tenement had ever, in writing, released the easement. He answered no. She asked him whether any subsequent purchaser of the servient tenement had ever filed a notice of intent to extinguish under Montana Code 70-17-111. He answered no. She asked him whether his client had any factual basis for installing a locked gate on a perpetual access easement without the dominant tenement holder's consent. He paused for a long time. He answered no. She said, "Then we are done." She ordered the HOA to provide me with the access code by close of business and to keep the gate open during agricultural delivery hours of 4 a.m. to 10 p.m. for the foreseeable future. Failure to comply would result in contempt and daily fines of $2,000. There were no questions. Madison received the order at 3:47 p.m. Outside the courthouse, Maeve and I stood at the top of the granite steps in the early afternoon Beaverhead County sunshine. The cottonwoods on the lawn had just leafed out. The sheriff's flag was at half-mast for a deputy from Lewis and Clark County who had been killed in a traffic stop the previous week. Maeve looked at me. She said, "Dad, we are halfway done. Madison is not going to take the order well. She is going to do something stupid before sundown. Get ready for the next phase tonight." I told her she sounded like her grandfather. She laughed. She said, "Dad, I should hope so." We walked down the steps. Maeve drove me home in her Volvo. Lally had made elk stew. We ate at the kitchen table at 6. I told Bryson on the porch afterward that the order had come down. He said, "Dad, she is going to lock the gate again by sundown. I would bet a yearling on it." I told him I would not take that bet. He drove home to his cabin at the east end of the property. He texted Maeve when he arrived. Maeve was already at the laptop drafting the contempt motion she would file the next morning. Madison did not comply. The gate was manually locked at 4:15 p.m. that same afternoon by her HOA gate manager, a man named Roy Tilden, 29, whom Madison had hired in March without a background check. Roy did not know about the court order. He had been told by Madison that the order was pending appeal. Roy padlocked the gate at 4:15. Sheriff Vince Hardesty arrested Roy at 4:48 under direct order from Judge Whitcomb. Roy was held overnight on a civil contempt charge. He gave a full statement to Sheriff Hardesty by 10 p.m. The statement described how Madison had directed him to override the court order. The statement was video recorded. The statement was 38 minutes long. Roy Tilden's statement included a small detail that mattered to Sheriff Hardesty's investigators. Roy had asked Madison, on the afternoon of the gate relock, whether the court order said what she said it said. She had told him the order was being appealed and that Mr. Kane has been harassing the community for years and the court will reverse this by Friday. She had told him to padlock the gate manually with a chain and a bolt cutter ready and to be prepared to claim he had not seen the order if questioned. Roy had not been comfortable. He had texted his wife Linny at 4:03 p.m. The text read, in full, "Babe, Madison is asking me to do something I think is illegal. If I get arrested today, call my mom and tell her I am sorry." His wife had screenshotted the text and saved it. The text was attached to Roy's statement as an evidentiary exhibit. The screenshot would, 4 months later, become the central piece of evidence in Madison's contempt of court count. Roy's wife Linny is now the assistant manager at the Dillon Albertsons. Lally still buys our laundry detergent from her. By Wednesday morning, Madison's defiance of the court order was the lead story on the Beaverhead County Tribune's website. By Wednesday afternoon, 3 of the 7 HOA board members had quietly contacted Maeve through their personal attorneys to ask what they should do. Maeve told them to call an emergency board meeting and to remove Madison from the presidency before the embezzlement case could implicate them. They did. Madison was removed from the board on Thursday afternoon by a vote of 6-1. The one was Madison. On the 18th of May, Maeve served the formal 90-day lease revocation notice on the Big Hole River Estates HOA at the management company's Helena office. The notice cited each of the 4 material breach triggers. The notice ran 14 pages. The notice was filed on the same day with Beaverhead County under Instrument 2024-1841, by coincidence the same trailing digits as the 1976 easement. Maeve had noticed the coincidence at the courthouse. She had said, in the parking lot, "Dad, Grandpa would have approved." I told her he would have. The 90-day clock ran through the summer. In the first week, the HOA's new acting president, a retired veterinarian named Quincy Lockhart, who had been my neighbor for 41 years, and Lally's veterinary supervisor for 19, drove out to the ranch with a 6-pack of Highland Park and asked whether we could find a way to keep the clubhouse standing. Quincy had been on the HOA board reluctantly for 6 years. He had voted against every Madison initiative he had been allowed to vote on. He had quietly kept his own notebook. He brought the notebook to my porch. The notebook documented Madison's diversions from the HOA Reserve Fund to her personal LLC, Cartwright Steel Consulting, totaling $34,400 over 3 years. Quincy had not known what to do with the notebook. He gave it to me. I gave it to Maeve. Maeve added it to the criminal complaint. The summer between the lease revocation notice and the new lease signing was the most peculiar summer of my 55 years on the ranch. The clubhouse pond was empty by the middle of June. The HOA had drained it under DEQ directive while the stormwater violation was investigated. The padlock on the clubhouse door had been installed by Sheriff Hardesty's deputy in front of 7 witnesses on the 25th of May, with a copy of the court order taped to the steel frame and a yellow Beaverhead County evidence sticker over the keyhole. The tennis courts had been roped off because the access road across the leased premises ran through the contested area. Big Hole River Estates residents, who had paid $2 million for second homes, spent that summer driving 38 miles to the Dillon Country Club for tennis and to the Beaverhead River for swimming. They did not blame me. They blamed Madison. Many of them dropped notes in our mailbox over those months, some signed, some unsigned, expressing sympathy and apology. Lally kept the notes in a wooden box on the kitchen counter. By August, the box held 83 notes. Most were short. One, from a retired federal judge named Helene Brooksley, who summered in Lot 33, was 4 pages long and ended with the sentence, "Mr. Kane, your father's revocation clause is the cleanest piece of property protection drafting I have read in 41 years of bench work. He saved you 50 years before you knew you needed saving." I framed Judge Brooksley's letter. It hangs in the hallway above the dollar bills. We negotiated through July and August. Maeve drafted a replacement lease. The replacement lease set the annual rent at $28,000, payable on the 1st of January each year. The replacement lease maintained the same 6 material breach triggers, with new language that any future filing by the HOA misrepresenting fee ownership of the leased premises constituted automatic termination. The replacement lease included a personal exclusion clause. Madison Cartwright Steele was permanently barred from setting foot on the leased premises for the duration of the lease and any renewals. The exclusion was recorded with the county. The exclusion was enforceable by Beaverhead County Sheriff's deputies. The exclusion ran with the property. Madison could not enter the clubhouse, the pond, the tennis pavilion, the parking lot, or any of the leased 8 acres for as long as the lease existed. If she did, she would be arrested for trespass. The HOA board voted to accept the replacement lease on the 8th of August by a vote of 6-0, with 1 abstention. The abstention was Madison's husband, Brody Steele, who had quietly been elected to the board the previous week to provide a face-saving family connection during the transition. Brody filed for divorce on the 17th of August. He moved out of Lot 47 on the 24th. Madison sold Lot 47 on the 3rd of February the following year. She moved to Florida. The new owners of Lot 47 are a retired couple from Boise who drove out to my ranch on their first weekend in residence with a casserole and an apology they did not need to make. The new lease was signed at a small ceremony at the Beaverhead County Courthouse on the 5th of September. The new acting HOA president, Quincy Lockhart, signed for the HOA. Maeve signed for me as my attorney. The Beaverhead County Clerk Eldon Briggs recorded the new lease in front of 43 Big Hole River Estates residents and a Beaverhead County Tribune reporter. Sheriff Vince Hardesty stood at the back of the room in dress uniform. Vince had been my classmate at Beaverhead County High School. The same year I had been a junior offensive lineman, and he had been the senior quarterback. He had been a deputy for 11 years before he won the sheriff's seat in 2014. He had attended Lally's mother's funeral, Bryson's wedding, Maeve's law school graduation, and 17 consecutive Cane Ranch branding suppers since 2001. He had brought his deputy Ed Pemberton, no relation to the Bozeman law firm, just a coincidence of regional surnames, who stood at the door with his Stetson in his hands. They were not there for legal effect. They were there for the part of the room that knew what the day meant. Lally sat next to me in her best Sunday cardigan, which she had not worn since Lieutenant Colonel Halverson's funeral in 2019. Bryson and Maeve stood at the railing. The courthouse signing ceremony was scheduled for 10 a.m. on a Tuesday. The lobby of the Beaverhead County Courthouse on a Tuesday morning at 9:30 is usually 2 people lining up for a marriage license and a 3rd person renewing a vehicle registration. That Tuesday, it held 48 Big Hole River Estates residents, 23 Cane Ranch hands and friends, a 4-person delegation from the Montana Stock Growers Association, 2 Beaverhead County commissioners, the Beaverhead County Treasurer, the Beaverhead County Tribune, 2 photographers from the Bozeman Daily Chronicle, and a quiet older couple from Wisdom, who had read about the case in the Salt Lake Tribune of all places, and had driven 3 hours to witness a property law happening. I shook the Wisdom couple's hands. They told me their family had homesteaded a parcel near Wise River in 1885. We talked about old Beaverhead County for 10 minutes. Their last name was Halverson. Different Halversons, just a Montana coincidence. And they brought me a small framed photograph of their grandmother, standing on her own porch in 1908. The frame was hand-carved. I took it home. Madison Cartwright Steele showed up at the courthouse uninvited. She walked into the room at 10:18 a.m. with an attorney I did not recognize. She tried to address the clerk. Sheriff Hardesty stood. He walked to her. He said, in his low, courteous voice, "Mrs. Steele, you are not permitted in this proceeding. The replacement lease includes a personal exclusion clause against you. The clause becomes effective at the moment of execution. We are about to execute. I am going to escort you out of the building." She started to argue. He took her elbow gently. He walked her out. She did not come back. The new lease was signed at 10:31 a.m. The clubhouse was unpadlocked the following Monday by Quincy Lockhart in front of 15 Big Hole River residents. The new keypad code at the eastern gate was reset to a 4-digit number Bryson and I had agreed upon, 1881, the year of the homestead patent. Every Big Hole River Estates resident received the code by certified mail. Every ranch hand had it on a laminated card in their wallet. The gate opens at 4 a.m. and closes at 10 p.m. It has not been locked against my family since. Madison was indicted on the 11th of October for forgery of a public document, the false affidavit, embezzlement, the consulting LLC diversions, and contempt of court, the gate defiance. She took a plea on the 14th of February. 14 months in Montana state custody. Restitution of $34,400 to the Big Hole River Estates HOA. Restitution of $11,500 to me for the cattle delivery loss and related damages. A permanent ban from serving on any Montana Common Interest Community Board. The personal exclusion from the clubhouse parcel was made permanent regardless of any future sale or transfer. Roy Tilden, the gate manager, took a deferred misdemeanor plea. 24 months probation. 200 hours of community service at the Beaverhead County Sheriff's Office. A written apology to me that he hand-delivered to my porch on a Sunday afternoon. He read it from a sheet of notebook paper. He cried while reading. Lally invited him in for lunch. We sat at the kitchen table for 2 hours. Roy is now a wrangler at the Crowfoot Guest Ranch up the valley. He is a careful young man. He has not made another bad call. The first of the new $28,000 annual rent payments arrived on the 2nd of January, the following year. Quincy Lockhart hand-delivered the check to my porch. I framed it. It hangs at the end of the hallway, in a larger frame than the 33 framed dollars. The frame is mahogany. The check is real. The hallway is, by now, a small documentary museum of the Kane Ranch's careful relationship with paperwork. The criminal trial of Madison Cartwright Steele was scheduled for February, but was preempted by the plea deal. Maeve and I attended the sentencing hearing in Helena on a Tuesday in March. The judge, a 64-year-old woman named Susan Whitcomb, niece of the trial judge from the Gate Injunction case, just a Montana coincidence of legal family names, read out the 4 counts and accepted the plea allocution. Madison stood at the defendant's table and read a prepared statement her attorney had drafted. The statement used the phrase, "regret the unintended consequences," 4 times. The statement did not use the word sorry. Maeve had told me in the truck on the way down that prepared statements in white-collar pleas rarely used the word sorry, because their lawyers had been trained to think it was actionable. I had told Maeve that I did not need to hear it. The judge had finished reading the order. Sheriff's deputies had walked Madison out. Maeve had squeezed my hand. We had driven home through the Big Hole River Canyon at sunset. We had not spoken. We had not needed to. The land outside the truck windows had been the land I had been driving past since 1965. The sentence had been served. The story was over. We used the lease income to establish the Tully Kane Memorial Beaverhead County 4-H Scholarship Fund. The fund pays the full registration and equipment cost for any Beaverhead County high schooler enrolling in a 4-H beef, sheep, or hog project. The first year supported 23 students. The second supported 31. Bryson teaches a Saturday morning calf fitting clinic at the rebuilt clubhouse. Yes, the same clubhouse. Once a month from October through March. Lally helps with the registration paperwork. Maeve drives over from Helena once a quarter to update the scholarship documentation. The fund is administered by Quincy Lockhart's daughter, Phyllis, a retired school teacher who took over the HOA presidency from her father in 2025. The Big Hole River Estates HOA and the Kane Ranch now host a joint annual fall barbecue at the clubhouse for both communities. Last year, we fed 246 people. We grilled a yearling steer Bryson and I had raised together since calving. We were out of meat by 7 p.m. The clubhouse itself is, structurally, the same building Crowfoot Development Group built in 1977. Cedar shake siding, stone fireplace, long west-facing porch over the pond. Inside, the wide plank pine floor still bears the small marks where the original developer's grand piano had sat for the first 10 years of its life. The new HOA board, under Phyllis Lockhart, voted in 2025 to mount a small bronze plaque inside the front entrance. The plaque reads, in the simplest possible language, built 1977, leased from the Kane family, in gratitude for 4 generations of neighboring. Phyllis presented the plaque idea to me on my porch one Saturday morning. I had not asked for it. I had not expected it. I had cried, a little, when I read the proof. Lally had cried more. The plaque was installed in March of 2025 in front of 41 residents and 20 Kane Ranch hands and friends. Phyllis read a short dedication. I said a few words. Quincy Lockhart said a few words. Bryson said one sentence. On behalf of the 5th generation, thank you. He had not told me he was going to say it. He had not told Maeve. He had walked to the lectern in his clean shirt and said it and walked back to his seat. The room applauded for a long time. The padlock that had been on the clubhouse during the 90-day revocation period hangs in my office. It is a heavy brass master padlock. The key is taped to the back. The key is not necessary. The padlock is just a souvenir. I show it to visitors sometimes when they ask about the framed dollar bills in the hallway. The padlock and the bills tell the same story from opposite ends. Bryson's monthly Saturday clinic at the rebuilt clubhouse has become a small Beaverhead County institution. The first Saturday of October brings 16 4-H kids from the Dillon and Wisdom chapters, 8 to 17 years old, with their own steers and lambs and one stubborn hog every year that gets renamed by lunch. Bryson teaches calf fitting the way my father had taught me. Slow, with the back of his hand on the animal's flank, with the comb working out of frame rather than into it, with a careful explanation each time about why each motion mattered. The kids listen. 2 of them, twins named the Brookmeyer girls, who are 12 and identical and who have never made a mistake at the show ring, have already qualified for the Montana State 4-H final the previous 2 seasons. Their father, a Cabot dairy hand named Ezra Brookmeyer, told me on the porch one Saturday in November that his daughters had paid for their own state entries out of the Tully Kane scholarship, and that he had cried the day the awards letter arrived. Ezra is a tall, quiet man who had not, by his own admission, cried in 20 years. He cried again that morning on my porch. I told him to keep the scholarship envelope. He said he was framing it. He is. It hangs in his kitchen. I sit on my porch in the evenings now, with a cup of coffee and Mavis, the old deaf Australian shepherd, at my feet. Mavis is 15 now and mostly retired from cattle work. And I watch the Eastern Road. The gate at 1881 is open every day from 4 to 10. My neighbors at Big Hole River Estates wave when they drive in. My ranch hands wave when they drive out. The clubhouse is full on Saturday mornings with 4-H kids and their parents. The pond is clean. The wetland downstream has recovered. The Kane Ranch is in its 5th generation of canes now. My grandson Cyrus, who is 4, rides in front of me on the small chestnut mare every Saturday morning. He has begun to ask about the cattle by name. I tell him. He remembers. He will remember. He already does. Last Tuesday he asked me about the mare's name. I told him she was called Lou. He has been calling her Lou for a week. Cordelia would have liked the name. So does Lally. So do I. If you have ever had a Karen lock you out of land your great-grandfather paid for, leave a comment below. Tell me what she tried. Tell me what you did back. I read every one. The stories you send me are the reason I keep telling these. If this one warmed you, hit subscribe so the next one finds you. Next week, we've got a single mother in rural Indiana whose HOA Karen tried to tear down her son's swing set. There is a wedding video the Karen did not know was running. That story is coming Friday. In the meantime, file your easements, frame your dollar bills, keep your father's revocation clauses. The county recorder is older than her keypad, and the law remembers. The framed dollar bills in the hallway are now 34. Quincy Lockhart hand-delivered the $28,000 check on January 2nd of every year of his presidency. Phyllis Lockhart has continued the tradition since taking over from her father. The 34th check is dated January 2nd of last year. The first 33 frames are small and cheap. The 34th is large and mahogany. Visitors to the hallway always notice the size jump. They ask. I tell them. Lally has begun to enjoy telling the story herself when I am not home. She tells it shorter than I do. Her version ends with the sentence, "And the old cowboy turned out to own everything." She has been waiting 4 years for that line. She uses it well. That is the story of the Eastern Gate.
First, this one is about something my own father used to say. He used to say a man should keep every receipt, every dollar, and every signature his neighbors give him over the years. Because the day will come when one of those neighbors will deny giving any of them. Madison Cartwright Steele did not lose because Agatha's kin was a meaner rancher than her. He was not. She lost because his father, Tulip Keynes, had insisted in 1976 on a 6-paragraph revocations clause that a Bosman developer lawyers had argued against for 40 minutes. The lesson, friends, is that the careful work of one generation protects the next, sometimes by half a century. If you have ever had a Karen lock you out of something your grandfather paid for, leave a comment below and tell me your story. I read everyone. They remind me we are not alone. Hit subscribe so the next one finds you. Next week, a single mother, a swing set, and a wedding video coming Friday.